Hello, this is Matt on the Moon Family Sedan channel. As most of you know at this point, the SEC defeated LBRY in their case, and there are headlines like the one on your screen from November 7th. LBRY loses SEC case, calls ruling a dangerous precedent for crypto. And I have the displeasure of reporting that LBRY has announced on social media that they're at a point where their death is imminent. And I'm going to show you the exact wording. But LBRY's, in all likelihood, going to cease to exist specifically because of this SEC lawsuit. It can't be financially sustained any further. And so even with whatever agreements the SEC and LBRY may come to, or if the judge ends up determining what's happening, what will happen in terms of penalties, which is more likely, I'll get into that as well. It just doesn't seem like LBRY is going to be able to pull through. And to be clear, what we're talking about is there was there were motions for summary judgment filed. Those were ruled, the judge ruled in favor of the SEC's motion for summary judgment. So now after that, that does mean that LBRY lost the case, but then settlement can still occur, which I know sounds weird. When I think of settlement, especially people like me who are not attorneys, when you think settlement, that's before the judge could decide anything. But this is not a jury trial, so it's different. If a judge... well, let's just talk about this example, obviously. The judge ruled in favor of the SEC, but that was one phase of developments here. Didn't get to specifically what the penalties would be. So what happens is you have LBRY and the SEC negotiating to figure out to agree upon what those penalties will be. So far, they're unable to. I'll show you the specifics here. But again, as a result of this, it looks like it could be the case that the SEC wants secondary market sales. So it'd be just like sales and transactions from exchanges from people having nothing to do with LBRY itself. Just the buying and selling on exchanges, secondary markets. It's a possibility based on the hinting that's been out there that that's what the SEC is looking for in settlement here. That's ridiculous, because if you can imagine how disastrous this would be. I mean, imagine it's the SEC v. Ripple case. Imagine if Ripple loses and as part of the settlement, the SEC says, yeah, well, part of the settlement terms here, now that you've lost Ripple, is that any secondary market sales till the end of time, even having nothing to do with you, those are also illegal securities transactions. So I've got comments from 4 attorneys within the XRP community on this, including, so that would include, I can name all 4, Attorney John Deaton, Attorney Jeremy Hogan, Attorney James K. Filan, and Attorney Bill Morgan. So I'll unpack all this for you. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so here's the couple of tweets from the official LBRY account from today, which read as follows. Since any information given privately to the SEC ends up leaking, we'd like to be upfront about the fact that LBRY Inc. will likely be dead in the near future. We expect the LBRY mission to continue on, but the company itself has been killed by legal and SEC debts. So I'll just pause to highlight just how disgusting and atrocious this is to me. It's just an entrepreneur. Entrepreneur is operating in good faith, trying to create some really cool stuff, and the SEC just wanted to sue them into oblivion, which it looks like they're on the verge of completing. And there is no path. Even after all of this, one of the things that's most disgusting, other than the fact that it looks like LBRY is going to cease to exist, is that there still isn't clarity. There still isn't a path forward. And investors are not protected as a result of what's happened. It's just disgusting. And then the separate tweet they wrote, the LBRY account wrote, it is specifically LBRY Inc. that must die. The LBRY protocol and blockchain will continue. And I did want to make sure that we clarify that. It's not the LBC token that's going to cease to exist. That's decentralized. That can't be stopped. And so you know how we've been saying for years it's ridiculous to state that XRP is a security of Ripple, and one of the reasons, obviously, is that if Ripple ceases to exist, XRP goes on. Same thing here. It's just as absurd. So it's then like, okay, so it's a security forever and for all time except LBRY no longer exists? I'm sorry, what, who? What? So you were wrong, SEC? I know. It's completely absurd, but this is real life now. Somebody named John asked the LBRY account, what about Odyssey? Now, Odyssey is the platform that's basically a video platform competing with YouTube. And LBRY responded and wrote, Odyssey will be fine and has a bright future. So it really does seem like it would just be the LBRY company itself that would cease to exist. But again, the blockchain's out there, and it looks like Odyssey, from what they said, is going to be able to continue existing, the LBRY protocol, all that. So that part's good. But man, I'm still just completely grossed out by all this. Now take a look at this, because it gets pretty disgusting even further. Check this out. So there was this shared by attorney Phylan, member of the XRP community. Shout out and credit to him as always. And he shared this letter from LBRY, which is written to the judge in the SEC v. LBRY case, who ruled in favor of the SEC. So they wrote to the judge in that case. Again, this is LBRY, and they said, "Dear Judge Barbadoro, we write on behalf of LBRY to provide a status report to the court with respect to the parties' settlement negotiations in the above referenced matter as requested by Your Honor during the November 21st, 2022 status conference. LBRY provided the SEC with a settlement proposal on Friday, November 25th, which was consistent with the framework laid out by Your Honor during last week's status conference. The parties discussed LBRY's settlement proposal today via a video conference and were unable to reach a resolution with respect to the remedies sought by the SEC. Accordingly, LBRY respectfully requests that the court order an expedited briefing schedule concerning the remedies sought by the SEC in this litigation." So basically, there were negotiations between LBRY and the SEC, and the SEC was not accepting the terms that LBRY set forth, even though LBRY stating that it was within the confines of what the judge said that he wanted. And as a result, LBRY's letting the judge know that, and it's now up to the judge to make a final determination in terms of the penalties. Now, it's worth noting, in the SEC v. LBRY case, this is an important fact, although LBRY lost, the judge punted a very important aspect of what we've been talking about for years now. It's the topic of LBC, LBRY Credit Token sales, on the secondary market. So just bought and sold from people on pick your cryptocurrency exchange, and not being sold by LBRY specifically. It's just secondary markets, and they could change hands again and again and again. All of those sales on secondary markets, the judge didn't even address that. He just punted it because he probably still doesn't know exactly what he wants to do. I'd be willing to hazard a guess. But now he's in this position where he's actually going to have to decide, it looks, because it looks infinitely unlikely that the SEC and LBRY are going to magically come to some sort of conclusion after this. I think this is the letter stating, yeah, we gave it a whirl. It's in your hands now, Judge. So now it looks like the judge may have to determine what are secondary sales in the market with the LBC token. And it gets especially ridiculous when you consider LBRY themselves are like, yeah, we're probably not going to exist from now. It's our death. So then what the hell is but still all sales moving forward, they're securities violations of what? A company that isn't about, or there is about to not exist? So LBRY responded to attorney Phylan there on Twitter and wrote, "Our counsel requested that we not post the exact offer, which is a shame, because it was basically, you can have everything we have," and they still rejected it. Now, folks, think about that. LBRY literally said, everything that's in our possession is yours, SEC. And the SEC said, no, that's not enough. What a bunch of asshat pricks. Attorney Hogan jumped in here, responded to LBRY, and wrote, "Let me take a wild guess. The SEC wants all the money made from past sales, plus a $5 million civil penalty, and further wants LBRY to agree to register any future sales with it." Which, by the way, is a pretty damn fair guess. If you think even back to the Kick Interactive case with the KIN token, there was at least, it may have been for some limited time period, but although Kick Interactive lost, and they were found to be in violation in terms of securities law, the KIN token itself, in fact, the KIN token exists today. You can buy it. I don't own any, but it's for sale. And for some time, I think it was for a limited time period, if memory serves. I could be wrong on that. But I think it was for a limited time period. if Kick Interactive wanted to sell any of their kin tokens, they would have to notify the SEC, and maybe they had to get approval or something to that effect. And so when Attorney Hogan here is guessing, let me guess, you got to pay a civil penalty, all the money from past sales, and you just have to, register any future sales. Totally reasonable guess. That sounds pretty well in line, frankly, with again, what happened with the Kick Interactive case. Now, a couple things here. Although I think that's a perfectly reasonable guess, LBRY didn't respond to that, but the LBRY account did respond to speculation from Attorney Filan here. So after the tweet where LBRY stated, our counsel requested we not post the exact offer, which is a shame because it is basically you can have everything we have, and they still rejected it. After that tweet, this is where Attorney Filan jumped in, and this is where it gets real interesting. Attorney Filan wrote, "Let me guess. That's because they want a consent judgment that also includes a specific agreement that every sale, even on the secondary markets, is a sale of a security." Whew. Now that would be wild. That's like some kind of a death blow. I'll tell you what, even outside of LBRY getting sued into oblivion, because that's about the token itself. Now again, of course, if LBRY ceases to exist, it's like, who do you sue now, right? So it's like, but what kind of blow is that? Well, think about that. If that were the conclusion found in the SEC v. Ripple case, not only did Ripple lose and a bunch of sales were in violation, like say that happens, but then if Ripple's going to exist in every single sale thereafter for as long as Ripple exists, at least, those are also securities transactions? Holy freaking hell. Now, LBRY responded to Attorney Filan, but did not respond to Attorney Hogan. And you can see it if you're looking at your screen already. LBRY responded with an emoji. That's it. It's an emoji face with zipper lips, as in lips are sealed here. Now, is that a hint that James Filan is correct and they're getting more aggressive in terms of settlement here now that LBRY's lost compared to what they were requesting / demanding in the Kick Interactive case? So they're getting more aggressive and they're talking about secondary market sales. Now, that would be something. It's very plausible. Here's what Attorney Deaton had to say in response to what Attorney Filan tweeted there. He said, "The entire world must see the disgrace, the absolute disgrace, the SEC has become. The SEC wants to annihilate the crypto market. At this point, I'm fairly confident that certain lawyers working at the SEC would actually enjoy individual crypto investors losing out." I don't put it past it at all. These SEC asshat pricks, I think they get all hot and bothered when they're even just thinking about this. They're just disgusting people. Here's what Attorney Morgan had to say, member of the XRP community. He also retweeted Attorney Filan. He said the following: "The judge put himself in a difficult position by writing a poor judgment that merely followed the SEC's arguments based on about half a dozen pieces of weak evidence and dealt badly with evidence to the contrary that supported LBRY's arguments. Now he has to deal with the consequences of what he ignored and hoped could ignore if the SEC was reasonable about penalties. How does he avoid destroying the project and avoid doing what the SEC is doing? Harming the investors it is meant to protect who believe in LBRY." Well, very well put, Attorney Morgan. And that's what I was saying a few minutes ago, and he's hitting the nail on the head here. It's like the judge punted the part that he didn't want to deal with when it comes to the penalties phase of this whole situation. Because again, just to reiterate, the SEC could have accepted whatever terms LBRY put forth. If it's the case that they're insisting secondary market sales also be included, as illegal securities transactions, well, now the judge has to deal with that. So he avoided dealing with that when he did the type-up responding to the motions for summary judgment, deciding in favor of the SEC. Again, he punted that whole topic. He didn't talk about it. Now he might have to. And that's what Attorney Morgan is part of what he's pointing out here in these couple tweets. So it'll be interesting to see what happens. It's just an absolute disgrace, though. It's disgusting that it's come to this. This is not right. What a bad ruling. It's just completely unfair to LBRY. It really is. It's just repulsive. I'll go ahead and wrap up here, though. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.